Hong Kong was returned to China in 1997 under the One Country, Two Systems principle, which is designed to safeguard certain freedoms for Hong Kong that are not enjoyed in other parts of China, such as freedom of speech and an independent judiciary. However, as part of this, the region was also required to enact its own national security law under Article 23 of the Basic Law. Due to public opposition, it never did this. In 2019, the government attempted to pass a bill that would have allowed Hong Kong citizens to be extradited to China for trial and sparked large-scale protests in Hong Kong, which saw nearly a quarter of the population take to the streets. The protests eventually evolved into a wider pro-democracy and anti-CCP movement. In response to the protests, the Chinese government stepped in to establish the national security law, providing the region with a legal framework to address what it perceives as significant challenges to its authority. According to the Basic Law, Chinese laws cannot be applied in Hong Kong unless they are listed in Annex 3. However, the National Security Law was added to Annex 3 by decree on the 30th of June 2020, bypassing Hong Kong's regional parliament. The National Security Law stipulates that the most severe penalties, including life imprisonment, can be imposed for acts of secession, attempting to break away from China, subversion, undermining the authority of the central government, terrorism, violence or intimidation against the population, and collusion with foreign forces to endanger national security. The National Security Law includes several significant provisions. Cases can be extradited to be tried in China. Hong Kong is required to establish its own National Security Commission with a Beijing-appointed advisor to enforce the laws. The chief executive is granted the authority to appoint judges to hear national security cases, while the list of designated judges is not made public, thus raising concerns about judicial independence. Beijing has the ultimate authority to interpret the national security law, rather than any Hong Kong judicial body, and the law takes precedent over any conflicting Hong Kong law. This was first used by Beijing in December 2022 to determine whether overseas lawyers are allowed to participate in the handling of cases related to the national security law. The Department of Justice can decide whether trials will be held behind closed doors and without a jury. Those suspected of violating the law can be wiretapped and placed under surveillance. The law will apply to non-permanent residents and people from outside Hong Kong who are not permanent residents under the principle of protective jurisdiction. Foreign non-governmental organisations and news agencies will face stronger regulation.
The four criminal charges are defined broadly and vaguely, which creates significant grey areas for the authority to determine whether defendants have violated the law. The role of Hong Kong courts has been weakened. If a designated judge makes a decision that the central government deems unacceptable, they may not be appointed to handle national security cases the following year, putting pressure on judges to handle cases without independence. The court has no power to question the work of the National Security Agency in Hong Kong. The independence of the judiciary is undermined, and the chief executive holds immense power without adequate checks and balances. Decisions made by the National Security Committee, chaired by the chief executive, cannot be reviewed by the judiciary. Chief executive has the power to issue certificates, determine whether certain evidence relates to the national security or secrets. There is a potential conflict of interest when chief executive is the chairman of National Security Committee and the one to appoint judges, while the government serve as the prosecutors in the court. Lawyers can use the platform and expertise to raise awareness about the situation in Hong Kong and the threat to the rule of law and human rights. Lawyers can provide legal support to Hong Kong activists and protesters, either by offering pro bono services or by helping connect them with legal resources. Lawyers can lobby the government and the international organizations to take action to protect the rule of law in Hong Kong, such as by imposing targeted sanctions on officials responsible for human rights abuses. Lawyers can build networks with their counterparts in Hong Kong and other parts of the world to share knowledge and resources and coordinate efforts to protect the rule of law. Lawyers can monitor developments in Hong Kong and report on any violations of the rule of law or human rights abuses in order to hold those responsible, accountable, and to inform advocacy efforts.
Follow us on our website and social media to receive updates on human rights lawyers in China and Hong Kong.